trying to keep up with all the new tech and arbitration, or the legal world as a whole, or even if you're just a curious person, it can be kind of overwhelming.
Oh, yeah, it really can.
There's just so much new stuff popping up all the time, new tools, new approaches, you know what I mean?
Absolutely.
Stuff to stay on top of it all.
It is, and that's exactly why we're zeroing in on something pretty important today. We're diving deep into the Chartered Institute of Arbitrators. That's CIArb for those in the know.
Right, CIArb.
They released a guideline in 2025 all about using AI in arbitration.
Makes sense. Everyone's talking about AI these days.
They are, but this isn't some basic manual telling you which AI software to download.
Right, right.
Think of it more as a high-level framework.
Okay.
It's meant to help everyone involved in resolving disputes. So the arbitrators themselves,
Of course.
the parties to the dispute, and their legal teams
Gotcha.
to really understand both the amazing potential of AI in arbitration,
Yeah, that's what everyone's excited about.
but also, and this is key, the potential risks as well.
Because there are always risks. Always two sides to every coin.
Always. So today, we're on a mission to distill
Yeah.
the most important nuggets of wisdom from this guideline.
Like a cheat sheet, almost.
Sort of. We want to cut through the noise and give you a clear picture of how AI is impacting arbitration right now.
Exactly.
And more importantly, what you need to watch out for as AI keeps evolving at this lightning speed.
Because it's not slowing down anytime soon.
Nope, it's not. We're
Huh.
aiming for clarity, not confusion.
Okay, I like it.
Uh.
So let's get into it. The CIArb guideline kicks things off by outlining the potential benefits of using AI in arbitration.
Right.
And the big one, the thing everyone's talking about, is increased efficiency
For sure.
and a potential bump in the overall quality of the arbitration process. I mean, who wouldn't want that?
Exactly. Faster, better, cheaper, right?
Yeah.
That's the dream.
That's always the dream. And one area where this is really obvious is legal research.
Yeah.
The guideline says AI-powered research tools, they're not just a small step forward, they're a whole leap.
They're a game changer.
Compared to traditional legal research methods,
Right.
like these AI tools, they can learn and adapt. They're not static.
Right.
And using something called natural language processing, NLP.
Yeah. NLP, it's a mouthful.
I know, right? But the point is, they can understand the nuances
Yes.
and the context of your legal questions, almost like a human researcher would.
Right. It's not just about matching keywords anymore.
So no more just throwing in some keywords and crossing your fingers.
Exactly. AI is taking legal research from being reactive, like a keyword search, to something proactive and context-aware.
Oh, that's interesting.
So you can find those precedents, those key cases, much faster and with more accuracy.
So it's like having a super smart research assistant.
It is. A research assistant that's constantly getting smarter.
I like it.
And then there's data analysis. Think about those really complex cases with mountains of documents.
Oh, yeah, those are fun.
Tons of fun. But AI can use text mining and analysis to process all that information at a speed that humans just can't match.
So it's like a speed reading champion on steroids.
Something like that. And what's really neat is they can actually spot conflicting statements within the text,
Oh.
which gives us an objective way to find patterns, connections, maybe even inconsistencies.
So instead of having like a team of paralegals going cross-eyed trying to find these little details.
Exactly. Imagine the time you save, especially in those massive, document-heavy disputes.
Huge time saver.
And AI doesn't stop there. It can actually help with generating text, too.
Oh, really?
Yeah, it can systematize, structure, even generate summaries of long chunks of text.
That's interesting.
So you can ensure your documents are consistent, grammatically correct, and clear.
That's a lifesaver.
Huge help for drafting those routine procedural documents. It keeps things uniform, reduces errors.
Yeah, because those little errors, they can really snowball.
They really can.
The guideline also briefly mentions evidence collection. The suggestion is that AI could streamline that process, make it more efficient and consistent.
It could. I mean, think about all the different types of evidence you have in a typical arbitration.
Yeah, it can be a lot.
AI can help with the organization, the analysis, make sure nothing falls through the cracks.
And then, of course, there's translation and interpretation.
Oh, a crucial one, especially in international arbitration.
Absolutely. I mean, you could have parties from different countries, witnesses speaking different languages.
And AI tools can translate those documents, even provide real-time interpretation during the hearings,
Wow.
including witness examinations. And what's really interesting is that AI could potentially even harmonize interpretation across multiple languages.
Harmonize. What does that mean?
So imagine you have a hearing with, say, 3 different languages being spoken.
Okay. Yeah.
AI could ensure the interpretation is consistent across all those languages, reducing the risk of misunderstandings.
Oh, because sometimes, even with human interpreters, there can be slight differences in how things are translated.
Exactly. And those subtle differences can sometimes lead to big problems down the line.
Yeah, that makes sense.
And then, you need a record of these proceedings, right? Transcripts of what was said.
Absolutely. That's crucial.
And the guideline points out that using AI for transcription, that could be way more cost-effective than using human stenographers.
So that could open up arbitration to more people, make it less expensive.
It could indeed.
Now, this is where things start to get really interesting for me. The guideline talks about something called case analysis.
Right?
And it sounds like AI can go way beyond those basic tasks like research and crunching numbers.
It's not just a back office tool anymore.
Yeah, yeah. It's like it can actually predict how a case might turn out
Right.
and even suggest which procedural strategies or arguments might be the most effective.
It's about those aha moments where AI helps you see potential solutions that you might not have spotted on your own.
It's almost like having a crystal ball, but for arbitration.
In a way, yes. It's not about replacing human judgment, but it adds a layer of predictive analysis that can really help with strategic decision-making.
I like it.
And finally, in terms of benefits, the guideline talks about something really important:
Okay.
the potential for AI to help level the playing field.
Yeah, that's a big one.
The inequality of arms issue.
Where one party has a lot more resources than the other.
Right. So if we can make these powerful AI tools affordable and accessible,
Right. Accessible to everyone.
then it could help those who might not have the budget for a huge legal team.
So they can still have a fair shot at justice.
Exactly.
Okay, so AI and arbitration, potentially faster, cheaper, smarter.
Sounds good, right?
It does sound good. But as we know, there's always another side to the story. Part 1 of the guideline also gets into the risks of using AI.
Right. We can't just ignore those.
And it sounds like some of these potential downsides are pretty serious.
They are. The guideline starts off with a big warning. It says if AI is used inappropriately or without really thinking it through,
Without due diligence.
yeah, it could actually hurt some of the fundamental aspects of arbitration,
Boy.
like the enforceability of awards, the guarantee of due process.
Which are kind of important.
Extremely important.
Yeah.
The rule of law itself, the administration of justice, the credibility of arbitration as a whole,
Wow, okay.
even the environment could be impacted.
Seriously.
Seriously. So transparency and a very cautious, well-informed approach.
Yeah, got to do your homework.
You absolutely have to. And one of the biggest concerns is confidentiality.
Right, confidentiality. That's like the foundation of arbitration.
It's essential. So when you start using these third-party AI tools,
Where you're sending all this sensitive case information out.
right, well, then you have to start asking questions about where that data is going.
Yeah, like where's it being stored? How's it being protected?
Exactly. And will it be used for the AI's own machine learning? Could it be accidentally exposed to people who shouldn't see it?
So many questions.
And it gets even more complicated because many AI systems, they're not standalone.
Okay.
They're interconnected. They rely on multiple tools and platforms working together. So trying to track exactly which data is being used where and for what purpose.
It's a nightmare.
It can be. So the CIArb guideline really stresses the importance of context.
Context.
Thinking about the original context in which the data was provided.
Okay.
Was there proper consent to use it in this way? And then robust confidentiality agreements are a must.
Yeah, you got to have those in place.
You really need to understand the security measures of the AI tools you're using.
So like, have they been vetted? Do they meet privacy standards? What kind of models are they running on, open or closed?
All of that. You can't just assume everything is secure.
It sounds like choosing the right AI tool, it's a big decision.
It really is. You have to do your research.
Okay, then there's data, integrity, and security. That's already a big worry with all these digital submissions in arbitration.
And AI could create even more vulnerabilities.
So everyone needs to be extra vigilant.
Exactly. The guideline basically says with AI in the mix, expect heightened cybersecurity threats.
From all sides, right? From the
Yes.
parties, from the AI providers themselves.
From everyone.
Okay, another big one the guideline brings up is impartiality and independence, particularly when arbitrators are using AI. The big fear here is bias creeping into the decision-making process.
Right. And we have to be really careful about how that bias can sneak in.
Okay, how?
Well, it could be in the data sets used to train the AI, If the data itself is biased, the AI will be biased.
Right. Garbage in, garbage out.
Exactly. Or it could be in how the algorithms are designed, how they're configured.
Okay, so it could be built into the system itself.
It could. And then there are things like affirmational authority bias, where an arbitrator might put too much faith in what the AI says.
Like trusting it too much.
Right. Or cognitive inertia, where they're hesitant to question the AI's output.
Even if their gut feeling says something's off.
Right. And the CIArb guideline is very clear on this point.
Okay.
Arbitrators, they're responsible. They're accountable for the decisions they make, even if they used AI to help them.
So AI can be a tool, but it can't be the decision maker.
Exactly. And the guideline draws a distinction between using AI for, say, searching for evidence.
Like finding a needle in a haystack of documents.
Yeah, which is generally considered lower risk. But if you're using AI to actually decide a key issue in the dispute,
That's a whole different ballgame.
it is much higher stakes.
So the human element, the arbitrator's own judgment,
That has to remain at the heart of the process.
can't hand over the reins to the machines.
Definitely not.
Okay, what's next?
Well, the guideline also talks about due process.
Another fundamental part of a fair legal process.
Absolutely. And AI could impact due process in a few ways.
Okay, how so?
Well, there's that inequality of arms issue again.
Right, if only one side can afford these fancy AI tools.
Exactly. Then there's the risk that one party might not even understand the case being brought against them.
Because it's based on some complex AI analysis that they can't decipher.
Right. And the guideline stresses that AI, if we're not careful, could actually limit how all the arguments and evidence are presented and considered.
That's not good. It's like crucial evidence being overlooked.
Exactly. Which brings us back to that idea of decision paternity.
Which means?
Basically, that the arbitrator is ultimately responsible for the outcome. They're accountable.
They can't just blame it on the AI.
Yep.
Okay, the guideline also mentions this thing called the black box problem.
Right. This one's a tough one.
It sounds kind of ominous. Black box.
It is a bit. So the issue is that with some AI tools,
Okay.
you don't really know how they got to their conclusion.
It's a mystery.
It is. Even if you know what data the AI was trained on and you know the basic algorithm.
The process itself is hidden.
Right. All those complex calculations and transformations happening inside the AI system, they're opaque.
We can't see them.
We can't. So it makes it really hard to double-check the AI's work.
To make sure it's accurate, reliable.
Exactly. And it also makes it difficult to explain the reasoning behind a decision.
Which is kind of important in a legal setting.
It's essential. And the guideline even mentions this scary possibility of AI hallucinations.
Hallucinations. Like AI seeing things that aren't there.
Pretty much. The AI can generate information that's completely made up, fabricated,
Oh, wow.
and present it as if it were true.
Like alternative facts.
Yeah, sort of, but it's not intentional deception on the AI's part. It's more like it's a byproduct of how it learns and generates information.
Okay, but that's still a problem.
Oh, absolutely.
Yeah.
It's a huge problem. It underlines the need for caution, for critical thinking when dealing with AI.
Can't just take everything it says at face value.
Definitely not.
And how does this all affect the enforceability of arbitral awards? I mean, if a decision is based on faulty AI, can it be challenged?
That's a good question, and the CIArb guideline does address it. The main issue is that AI technology is moving so fast.
It's evolving at warp speed.
It is, and the legal and regulatory landscape is struggling to keep up.
Yeah, the laws are always a few steps behind the technology.
Always. So there's a lot of uncertainty about how courts will view AI-assisted decisions in the future.
Okay, so what's the takeaway here?
Well, the guideline basically says, be careful, make sure the AI tools you use and the way you use them.
They don't violate any mandatory rules or laws.
Right. Because you don't want to end up with an award that can't be enforced.
That would be a waste of everyone's time and money.
It would. And the guideline even mentions the environmental impact, just briefly.
Oh, yeah.
Some of these AI tools, they use a lot of energy to run.
So there's an environmental cost, too.
There is. Something to keep in mind.
Okay, so the overall takeaway from the risks section.
Is that the level of risk, it really depends.
On what?
On the specific AI tool you're using, how you're using it, and the specific arbitration you're dealing with.
It's not a one-size-fits-all situation.
It's not. You have to do your due diligence, assess the risks carefully.
Okay, so we've talked about the potential benefits. We've talked about the potential downsides. What does the CIArb guideline recommend for actually using AI in arbitration? Like, what's the practical advice?
Well, Part 2 of the guideline lays out some general recommendations. It's for both the parties involved and for the arbitrators themselves.
Okay, so everyone needs to be on the same page.
Right. And the first recommendation is pretty straightforward.
What is it?
Ask questions. Do your research on any AI tool you're thinking about using.
Don't just blindly trust it.
Exactly. Try to understand the underlying technology, how it works, what kind of data it's using.
So, like, read the manual.
Essentially, yes. The second recommendation is about weighing the pros and cons.
Risk versus reward.
Right. And the guideline says, don't just focus on potential efficiency gains.
Okay.
Think about the impact on due process, the rule of law, the administration of justice, the credibility of arbitration, even the environment.
So it's a bigger picture view.
It is.
Yeah.
And then it recommends looking into any relevant AI-related law and regulations in the jurisdictions involved.
Because that legal landscape is constantly changing.
It is. And finally, a really important point, the guideline says using AI doesn't mean you can just shirk your responsibilities.
Like, you can't just blame the AI if something goes wrong.
Exactly. The human participants are still accountable for their decisions.
That makes sense. AI is a tool, not a scapegoat.
Exactly.
Okay, so part 3 of the guideline, it talks about how arbitrators can provide directions and make rulings about how parties use AI.
Right. They have a crucial role to play.
It's like they're the referees of the AI game.
In a way, yes. And the guideline says that their authority to regulate AI use, it comes from their general powers to conduct the arbitration.
To make sure things run smoothly.
Exactly. And they can issue directions, make procedural rulings as they see fit.
But always within the boundaries of any agreements the parties have made.
Right. And any mandatory laws or institutional rules that apply.
Gotcha. And it sounds like arbitrators can even bring in experts if they need help understanding a particular AI tool.
They can. If they need specialized advice, they can appoint an independent AI expert.
Someone who really knows their stuff.
Exactly. And the ultimate goal is to make sure the AI is used in a way that protects the integrity of the arbitration process.
And ensures that the final award, it's valid, it
Oh.
can be enforced.
Right. Now, to answer your earlier question, yes, arbitrators can step in and make decisions about AI use.
Even if the parties haven't agreed on anything beforehand.
They can. They wouldn't typically get involved in how parties use AI privately.
Okay.
Like if it doesn't affect the arbitration itself, and it's okay under normal litigation rules.
Right.
But they can require disclosure if they think the AI use might impact the process.
Transparency is key.
It is, and the guideline says put any decisions about AI use in a formal procedural order.
So everyone's clear on what's allowed and what's not.
Right. And these decisions, they can be revised as the case goes on if needed.
It's not set in stone.
It's not. And if a party doesn't follow the arbitrator's directions on AI use, well, there are consequences.
Like what?
The tribunal can draw adverse inferences against that party.
Like assume they were trying to hide something.
Yeah. Or they can consider the non-compliance when deciding how to allocate costs at the end.
So there's a financial incentive to play by the rules.
There is.
Okay, so open communication, clear directives from the arbitrators, those are really important.
Absolutely. And the guideline also talks about party autonomy.
The parties' right to make their own decisions.
Exactly. They can agree on whether to use AI, how to use it.
Subject to any legal limits, of course.
Of course. And they should check their arbitration agreement
To see if it says anything about AI.
as soon as they get a request for arbitration. And if the agreement doesn't mention AI, the guideline suggests that the arbitrators,
They should bring it up with the parties.
early on, maybe at the first case management conference,
So everyone can talk about it.
right, they can discuss which AI tools might be useful, how they could be used, the potential risks, anything important.
Sounds like a collaborative approach.
It is. It's about having an informed discussion.
And if the parties can't agree, or if the arbitrators think the AI use is jeopardizing the fairness of the process.
Then the arbitrators can step in and make a ruling, even if they have to do it on their own initiative.
After consulting with the parties, of course.
Of course.
So what factors do arbitrators consider when they have to make a ruling like that about AI use?
The guideline lists a few key things. First, they'd look at the potential benefits of the AI tool.
Like, will it save time or money?
Right. And they'd weigh those against the risks.
Could it mess with the evidence, the fairness of the process, confidentiality?
All of that. They'd also look at the AI tool itself. What data was it trained on? Does it have any biases? Is it reliable? Is it secure?
Gotta make sure it's a good tool.
Exactly. And when thinking about bias, they'd look at the training data.
Make sure it's not skewed.
Right. They'd check if any debiasing techniques were used, if there have been any independent audits for bias.
So a thorough vetting process.
It is. And they also need to make sure any AI-generated content, it's properly linked to the original source data.
So you can trace it back, make sure it's authentic.
Exactly. And the guideline makes it very clear that arbitrators, they have to follow all applicable laws and regulations.
Even if those laws aren't specifically about AI.
Right. There are broader laws about privacy, cybersecurity, intellectual property, competition.
So they have to consider all of that.
They do. It's complex, but it's important.
It is. Okay, the guideline also has a whole section on disclosure of AI use.
Right. Transparency is key
Why is that so important?
because it ensures everyone's on the same page. If an AI tool is being used in a way that could affect the evidence, the outcome of the arbitration, or if it involves delegating a task that a human would normally do,
Okay,
then that use needs to be disclosed to everyone involved.
no secrets.
Right. And unless the parties agree otherwise, arbitrators can actually require disclosure.
So they have the power to say, you have to tell everyone you're using AI.
They do. They can specify what type of AI, when disclosure is needed, who needs to know, the timelines.
The very specific instructions.
They can be.
Yeah.
And the duty to disclose, it continues throughout the whole arbitration.
You can't just disclose it once at the beginning and then forget about it.
Right. And arbitrators, they also have to be aware of any confidentiality issues.
Or other legal reasons why disclosure might be tricky.
Exactly. And if a party doesn't disclose their AI use when they're supposed to,
There could be penalties?
there could. The arbitrators might draw negative inferences.
Like assume they were hiding something.
Or they might consider it when deciding costs.
Okay, so there's a real emphasis on transparency and accountability when it comes to parties using AI.
There is.
Now, what about when arbitrators themselves want to use AI? Is that allowed?
It is. Part 4 of the guideline covers that. It says arbitrators can use AI.
But there's some big caveats.
There are. The biggest one is that AI can't replace the arbitrator's own judgment.
It's a tool, not a replacement.
Exactly. AI can help with processing information, analyzing things,
Like a supercharged research assistant.
but the final decision, the reasoning behind it, that has to come from the arbitrator.
The human element is still essential.
Absolutely.
Yeah.
And the guideline says, don't use AI for things that could threaten the integrity of the process.
Like what?
Things like delegating really important legal analysis, fact-finding that involves interpretation,
Okay.
applying legal principles to the case if it will directly affect the outcome.
Those are the arbitrator's core duties.
They are. And arbitrators are told to double-check any information they get from AI, to be aware of their own biases, to do their own research alongside the AI, to stay critical, to question things.
So basically, don't just blindly accept what the AI says,
Exactly. And ultimately, the arbitrator is responsible for the award.
regardless of whether they used AI or not.
It's their signature on the line.
And what about transparency when the arbitrators use AI? Do they have to tell the parties?
Yes, they're strongly encouraged to consult with the parties before using any AI tool.
To give them a heads up.
Right. And give them a chance to comment, maybe even object if they have concerns.
And if the parties disagree.
The arbitrator should probably avoid using that specific tool.
So the parties have some say in the matter.
They do. And even if everyone agrees, the arbitrator should still think carefully about the risks.
No such thing as being too careful.
Right. And if there's a tribunal with multiple arbitrators,
Okay.
they need to talk to each other about their AI use, make sure everyone's on the same page.
So no one's doing something that could jeopardize the process.
Exactly.
Okay, the guideline also mentions 2 appendices.
But it does. Appendix A is a template for an agreement on AI use.
So the parties can use it as a starting point to figure out the ground rules.
Exactly. And Appendix B is a template for a procedural order on AI use.
Which the tribunal can use to formally document the procedures.
Right. So these appendices, they're practical tools to help put the guideline into action.
And make it less theoretical, more concrete.
Exactly.
So the big picture here is that AI has a ton of potential to make arbitration better.
It really does.
But we have to be very aware of the risks, manage them carefully, be transparent, ask questions, understand the limits of the technology.
It's about using AI responsibly, ethically.
That's a good way to put it. And for you, our listener, here's something to think about. How do you think AI will change the practice of arbitration in the future? Your role within it. What are the biggest challenges, the most important things to consider as AI becomes more common in dispute resolution?